Chair.
Call Jacinda Ardern.
Thank you, Mr. Chair. The Minister spoke to an issue that I'm quite interested in as well, but I want to delve into a little bit further, and that is speaking to the amendments that are made in supplementary order paper number 56, which I note, interestingly, is actually longer than the bill itself that we're debating. So it seems that the SOP is obviously of reasonable importance. It also seems like it reads like a bit of an afterthought, an opportunity to make some amendments where errors again were made. Just to clarify though, and I'm not sure whether or not the Minister really spoke to this point, I think it was interesting, the point that Ron Mark raised, obviously, is that if you read section 79 of the original Social Security Act 1964, it already does point out that where any person is being employed outside New Zealand, or while so employed, was liable for the payment of income tax on earnings from that employment for the purposes of satisfying the regional residential qualification under New Zealand purposes for benefits. Now, the way I read that, though, is that a person is employed outside New Zealand and while so employed was liable for the payment of income tax on earnings from that employment. So it's quite specific almost. It's saying if you're employed outside New Zealand, but that employment that takes you outside New Zealand, that employment and those earnings are liable for income tax in New Zealand. One could assume a number of roles where that might be the case, for instance. I wonder if you were in an NZTE role, perhaps, or something like that. For those purposes, you're considered to be paying tax in New Zealand, obviously, and therefore still would qualify upon return for New Zealand benefits. That seems pretty straightforward. So the change then what we have in the supplementary order paper reads, and it replaces section 79, reads, persons who have had income tax deducted or withheld on earnings from employment overseas to be treated as resident and present in New Zealand. This section applies to any person who was employed outside of New Zealand if, with respect to the person's period of employment, the person's employer or other relevant person makes PAYE income payments from which the person, employer, or other relevant person must withhold an amount of tax under the PAYE rules as defined in that Act. It seems to me that these two provisions are doing very similar things. I would be interested as to why it is that the specificity around PAYE is that simply to bring it into alignment with the Income Tax Act 2007. Is that the main purpose? Or is there a functional change to the type of income that is deemed to be relevant by having this change? Because it seems to me that the original legislation seems like a broader catch-all to me than the subsequent amendment that we're making, which is very specific towards PAYE. So I'd be interested in the Minister's comment as to why that change was deemed necessary. Mr. Chair, I'm also interested in these SOPs. We are making an amendment that alters the qualification of someone for a relevant benefit in New Zealand, and we can assume that the most likely benefit that will be covered by these provisions would be New Zealand superannuation. That's probably the thing that's going to be, because of the qualification test around residency in New Zealand. You basically have to have been an income earner in New Zealand for a specified period of time, and then five years before the date of your retirement. So basically, resident in New Zealand, earning an income and paying tax, or living here 5 years before the point at which you retire. And if you don't, then you have to stay here for an extra 5 years before you're eligible. That's basically, in a nutshell, the rule. However, your eligibility is also affected, Mr. Chair, by other forms of pension entitlement that you might have. So, for instance, say under Section 79, you were one of these individuals that went overseas, paid income tax in New Zealand, but whilst you were overseas, you may have also been eligible to pay into an overseas pension scheme. Now, if that were the case, even if you qualify, Mr. Chair, for a New Zealand super when you return, because you qualify under even the amended Section 79, Under the current rules in New Zealand, Mr. Chair, I have 3 seconds to go and I will be seeking another call. Mr. Chair. Mr. Chair. Thank you, Mr. Chair. Even if you do come back at that point, you've qualified for all intents and purposes, you've been paying income tax. If you come back with an overseas pension, then Section 70 of the Social Security Act will apply to you. Now, Section 70, Mr. Chair, is a very controversial section of the Social Security Act. Most members of this House who conduct any form of constituency work will be familiar with this section of the Act. It allows MSD, if you have an overseas pension which is considered to be equitable or similar to the New Zealand superannuation scheme, New Zealand superannuation, then MSD can deduct dollar for dollar from that overseas scheme. Dollar for dollar. Now, the reason that they do that, we've been doing this direct deduction policy since 1938. That's the time period in which it's been happening. At that time, probably there weren't so many people who were eligible for overseas pensions. Since that, great Minister, that's right, it's time. But 12% now of our superannuitants are eligible for an overseas pension, and I would wager that that will continue to grow. Now, the issue with this policy, some would say, okay, it's fair. No one should really, if they've spent obviously enough time overseas to be eligible for an overseas pension, should double dip, come home, be able to be eligible for New Zealand super, collect the overseas super and get that double whammy. If they're going to collect that and it's similar to the New Zealand scheme, let's just deduct until they end up getting the same amount that everyone else in a pension scheme would. The problem is making a judgment over what overseas pension schemes are similar to ours and what aren't. And that's where there seems to be a real injustice in the way that the direct deduction policy works. I've seen countless cases of pension schemes which have been contributory, where someone has put in their own money into a scheme, come back to New Zealand, assume that they're going to be able to draw down that scheme which they've contributed to, only to then have that deducted from their New Zealand super entitlement. Now, you can argue the rights and wrongs of a scheme like that. What you cannot argue, in my mind, is that under that policy, if they deduct right down to zero, such as the generosity of that alternative scheme, MSD will then start deducting from your partner's entitlement. What? Someone who might not have even lived overseas, may have only known you for the last 10 years, they will have their pension deducted instead of yours because you've reached full entitlement. Now, that cost, from memory, that saves the New Zealand government roughly $5 million a year, that specific provision. But it is totally unfair. It's in my mind, it is a human rights violation because this predominantly affects women who have their entitlement deducted. Their entitlement is their entitlement. It should never be affected by anyone else's. So the point that I raise, Mr. Chair, for the Minister is this. If we are looking at eligibility criteria, if we're looking at who's eligible for New Zealand pension, who's been overseas, why not look at the big stuff? Why not look at whether or not in this changing globalised environment where more and more New Zealanders are working offshore, where more and more are contributing to an overseas pension scheme, I had one, that actually whether or not our scheme is equitable anymore. Now, New Zealand First has a policy on this, and Labour, before the last election, tried to get the Select Committee to review this issue because it was so difficult to navigate for so many people. That was turned down by the Select Committee, unfortunately voted down by National. But we have given our commitment that we will review the direct deduction policy with a view to removing the unfairness of this scheme, the fact it's antiquated and no longer caters to the modern environment, and the fact that so many schemes actually aren't similar to New Zealand schemes and yet are being treated as such. So, Minister, I would have hoped that alongside SOP number 56, that it would have been a prime opportunity, alongside reviewing Section 79, to review Section 70, to at the very least acknowledge the point that's been raised by the Human Rights Commission over the deduction of pension of a partner's pension, and or at least commit to reviewing the rest of the inequity that exists in our scheme currently, Mr. Chair.
Mr. Chair. No, Matt Duthie.
Thank you very much, Mr Chair. It's an honour to rise and take a brief call on the Social Security Amendment Bill number 3. I'd very much like to take the time to focus on the nub of the debate around student allowance versus the accommodation and supplement. But first I'd like to take a step back and say how proud I am to live in a country that has a Social Security Act, and it is right